Well, the question isn't so much public versus private streets, because typically in those types of associations, the roads are either dedicated or owned by the association. So strictly speaking, they're most of the time anyway, not public roads, so they're private. But I think really kind of the question is whether or not the association is allowed to tow from someone's driveway versus some type of parking area. The way the statute reads is that the association is allowed to tow vehicles under certain circumstances from common areas. So if you're in an HOA and you have your driveway, that's not a common area. So they can't come up into your driveway and say, well, you got the wrong type of vehicle here, so we're going to tow it. You know, they can fine you, they can do other things under the declaration, but they can't come on to your property and tow your vehicle. Now, if there is like a common parking lot or overflow or overfill within an HOA, that would be common area, and they would be allowed to tow from that area. If, as I mentioned before, if somebody parks out on the street, that would be a common area of the HOA, and they would be allowed to tow under certain circumstances. In a condominium association, typically the parking is common area. Now you can have assigned ones, which would be limited common areas. Yeah, so the question really comes down to common areas versus purely private areas owned by the unit owner or the homeowner. And so if it is just for the unit owner or the homeowner, then their towing statute doesn't apply and the association cannot tow. But if it's within the common area and there's a violation and the association follows the statute strictly, then they're allowed to tow vehicles.